Good evening and welcome. It's now 6 o'clock and I'm handing over to Dr. Mzukwa, the chairperson of the association. Thank you.
Thank you so much, Reniel, and good evening, ladies and gentlemen. On behalf of the South African Medical Association and Mediation in Motion mediators, thank you for joining us this evening for the launch of an exciting campaign, an alternative dispute resolution unit that will provide doctors and patients with a platform where complaints and disputes can be resolved amicably without resorting to costly and adversarial legal proceedings. It is not a secret, ladies and gentlemen, that the field of healthcare is a complex and rapidly evolving landscape where medical professionals work tirelessly to provide quality care to patients. However, disagreements and disputes can arise, leading to legal conflicts that may affect patients' care and professional relationships. Traditionally, litigation has been the go-to route for resolving such disputes, as you know, but mediation is gaining ground as a preferred alternative and more constructive approach to resolving conflicts within the medical community. In South Africa, as in many parts of the world, we recognize that litigation can be a lengthy, costly, and adversarial process. It often fosters a win-lose mentality, which can damage professional relationships and, at times, erode trust within the healthcare system. This is a significant concern in a field where collaboration and communication are essential to developing high-quality patient care. Mediation, on the other hand, offers a more collaborative and less confrontational method of resolving disputes. It provides a structured and confidential environment where parties can openly communicate, express their concerns, and work together to find mutually acceptable solutions. The process is guided by a neutral mediator who facilitates the conversation and helps the parties reach a resolution that can benefit all involved. Today, we'll hear from experts in the field of mediation and healthcare who have first-hand experience in resolving medical disputes through mediation. They will share their insights on the advantages of mediation, such as preserving professional relationships, reducing stress and costs, and ultimately leading to a better patient care. I encourage all of you to actively engage in the discussions and to ask questions as we explore this vital topic. It is now my pleasure to introduce you to Dr. Mark Human and Dr. Trevor Frankish, who will provide background information on the mediation project. Dr. Human is a summer board member and chairperson of the Gauteng Branch Council. He also chairs the Human Rights, Law and Ethics Committee and serves on Summer's Health Policy Committee. Dr. Human is an experienced general orthopedic specialist in private practice and is highly skilled in arthroplasty, arthroscopy, and general orthopedic trauma, hand and foot set, sports injuries, and musculoskeletal trauma. He is passionate about finding alternative solutions to medical complications or adverse events that do not involve litigation, and also obtained a diploma in mediation. On the other side, Dr. Frankish is a member of both SAMA and Mediation in Motion mediators. He is registered as a specialist in family medicine and holds an MSc Med degree in bioethics and health law. He is also a member of the SA Medical Legal Association, that is SAMLA. He is involved in various clinical projects with a private hospital group and has management experience in both the public and private sectors. In addition, Dr. Frankish is involved in a project mediating medical legal claims against a provincial health department. This project, under the auspices of SAMLA, has done 50 mediations, with mediators providing their time and expertise pro bono. Over to you now, Dr. Human and Dr. Frankish. Thank you so much.
Thank you very much, Mrisi. I'm just going to say a couple of words, and then Trevor's very kindly going to take over and do a short presentation on the history of how all of this came about. It should come as no surprise to most or many of us that medico-legal challenges and the problems that they create right from the start for patients, relatives, and the profession as a whole are one of our most significant challenges, one of the biggest problems that we have to deal with, and that healthcare will have to deal with going forward. So there had to be some kind of a solution proposed, and coming out of the Gauteng branch some 5 years ago was the start of some ideas that have finally culminated in this project 5.5 years later. Trevor's going to give us a more detailed intro into how exactly it all came about and how we were approached by the Gauteng Department of Health and exactly how it took place. It's obviously morphed into something much bigger, and along the line, after trial and error, working out that we would not be able to run this thing on our own completely, and that we needed to partner with people who have a pre-existing experience and a template for how to deal with these things. That's where the partnership with Mediation in Motion Mediators came about. Trevor, over to you, and I'm going to share my screen. If you can just let me know to advance the slides as you need them.
Thanks, Mark.
1 second here. Okay, let's give me a presenter mode. Okay, over to you, Trevor.
Right, thank you very much. Appreciate that. What's showing on my screen is still just the update. I'm not sure if you've moved on to the next screen. Can we check with,
apologies.
Okay, just check with others. Which screen there? Okay, perfect. Can just go back up. Yeah, go one. Yeah, so the next slide, please. So thanks very much. I just want to, we don't really want to focus on the past, but just for participants to understand that there is a bit of a history from the South African Medical Association, particularly Gauteng branch, following the involvement with a meeting with the MEC for Health in about 2018. There was a particular crisis within the health department at one of the hospitals, and SAMA engaged the then MEC to ask how they could help. So that was about 2018. So in particular, the MEC asked for assistance with medical negligence claims against Gauteng. And after discussion, actually with Prof. Ames Dye and from the Steve Biko Center for Bioethics and Health Law, or Center for Bioethics, a proposal was prepared and taken to the Chief Director of Special Litigation in the Gauteng province. But at the same time, SAMLA, the Medical Legal Association, was also approaching the Department of Health to offer their services. They were pro bono, and as Mark has mentioned, was mentioned in the CV, that project has now delivered 50 mediation cases or 50 mediations to the Department of Health. Not going to go into the successes and so on, but just so that you know, this has been a bit of a journey. Anyway, SAMA continued to be interested in establishing what was called an alternate dispute resolution unit. We looked at costing and so on, but there's a great deal of uncertainty about what would be the take-up of either alternate dispute resolutions or mediation in particular. A lot of misunderstanding, there's a lack of knowledge about what mediation is, and hopefully this evening we'll share with you what mediation is and the pros of that. I think, yeah, so then in last year, Medical Association decided to actually outsource to an entity which had considerable media experience, particularly in the field of medical mediation. And that's how we've ended up where we are. There is an MOU between SAMA and Mediation in Motion mediators. So I'm not sure if everybody else has got the screen just flashing, but we'll just briefly go through that. So I'm going to hand over now to Advocate Alan Nelson, and he will just describe to us what mediation is and its advantages over litigation. So I think Shamal is going to share from this point, Mark, if so we can just continue sharing.
Well, yeah. Shamal, will you come in first, please? Or would you like me to continue straight away? So, good evening, everybody. It's a great privilege and a pleasure to be here to address all of you. I know that I've met quite a lot of you, but not all of you. And it's certainly yeah, very good to be here and to talk to you about something that I'm very passionate about. I'm a senior advocate, was at the Cape Bar and acted as a judge for a while. With kind of 40 years of life spent in the adversarial way of dealing with conflict in courts. I also acted for the Medical Legal Association. And yeah, I have also for the last 10 years been extremely privileged, and I want to stress that, to be able to deal with conflict in a consensual manner. So if we strip everything and we go down to basics, there are essentially two ways of dealing with conflict. One way is consensual, and the other way is adversarial. So you either take up the fight mode to deal with conflict. You can physically fight, of course, but you can also go to court, or you can arbitrate, and that's a fight mode of dealing with conflict, where there's one winner and one loser, as has been mentioned this evening, or you can try to find consensual solutions to conflict, where we essentially get people off their positions and get them into a collaborative mode so that they can together work out solutions to their problems. If you can perhaps please just advance the slides. There is a slide that has been prepared that illustrates the differences between the adversarial way of dealing with conflict and the consensual way, and I'd like to focus on just some of the essential differences between litigation on the one hand and mediation on the other, so that you've got a good understanding of exactly what those differences are. I don't know if you can advance the screen sharing slides for me, please. Doesn't look like it. All right. Okay, there we go. So the first huge difference, and I'm going to give you some examples. The huge difference between mediation and litigation is time. So if you want to run a case to court and you want to resort to the adversarial mechanism for dealing with conflict, you can set aside between 5 and 10 years of time in order to have a decision from a judge. It could be an appeal court, or it could even be a court of first instance. And there are many cases which demonstrate that you're looking at a period between 5 and 10 years to deal with something through an adversarial court process. Mediation, on the other hand, 90% of cases that are mediated are resolved to the satisfaction of both parties. I think that's something worth stressing. And the time period taken in 70%, that's an international statistic, of all of those matters, time taken in 70% of them is a day or less. 1 day or less. And we strongly believe, as mediation in motion mediators, that we should address conflict as soon as possible. We shouldn't wait even until all the details and the nitty-gritty is sorted out. And I'll tell you why that is in a moment. So essentially, if you're in a dispute situation, within a matter of months, if you resort to a consensual mechanism for dealing with that conflict, the conflict can be over. It can be dealt with. It can be resolved. It can be off your back, versus a period between 5 and 10 years, and in some instances, even longer than 10 years. You have this thing hanging over your head, and the patient has it hanging over their head as well, if you resort to the adversarial mechanism for dealing with conflict. The second thing is cost. The cost difference between mediation and litigation is massive. We have done a statistical analysis of cases that have gone through the court process and that we have mediated in role plays, and the cost of mediation versus litigation is less than 1% of what litigation costs. Litigation is enormously expensive, and especially in medico-legal matters where they are normally complex and they take a lot of time. So the cost advantage of mediation is massive, massive compared to litigation. And I think probably for me, the most important difference between litigation and mediation is the issue of personal trauma. If you litigate, you are inviting the most traumatic experience that life can imagine. Okay, it differs. I mean, in a matter that just deals with fees, that's one thing. But in a matter which deals with somebody who suggests that you've not acted according to the standard of your calling, that is a huge dignity invasion. And that causes huge trauma. But by the same token, a patient that has got an unexpected outcome also suffers massive trauma. If we have disputes between medical practitioners that have different perceptions and different views about things, that can also result in huge trauma. I've been involved in matters where medical practitioners, specialists have been involved in disputes with hospitals. Massive trauma caused by that, as opposed to mediation, where within a period of a few months, everything can be resolved in a manner that is satisfactory to both parties. And I think, let me just stress here that litigation, we look backwards. In litigation, we look backwards, we look at what happened, we assess the facts, we then take the law and we apply the facts to the law. And neither of those are clear. To say that, for example, somebody not acted according to the standard of their calling, that's a very difficult thing to decide. And people can differ. We have so many cases involving medico-legal disputes which have been upset on appeal, where the appeal court judges looking at exactly the same facts come to a different conclusion, a hugely different conclusion. So when we look at mediation, we don't ignore what happened. Of course, you always have to look at what happened. But the focus is not on deciding who's right and who's wrong, looking backwards. The focus is on getting the parties to shift off their positions and look to the future and decide an outcome based on what's really important to them looking ahead. And that's the essential difference between these two mechanisms. So in mediation, we really shift the focus. We get people to move off their positions, to look at the future and to say to themselves, what's really important to me going forward? What's really important to the practitioner? What's really important to the patient? Or to two doctors, or to a hospital-doctor relationship? And then to couch solutions based on that. And that brings me to the fourth difference. In litigation, you've only got money. So much money, how much money? In mediation, you've got endless possible solutions. Whatever the parties are satisfied with, whatever they're happy with, can be a solution. I've had one case, in fact, where a medical practitioner has allowed a patient to use his seaside home for a period. Wonderful solution to a problem where the parties started talking and looking for all these inventive ways of just helping one another take care of a problem that occurred in the past. So in mediation, the outcome is based on the needs and the interests and the concerns of the parties looking really ahead. We try in mediation to focus on what's really important to the parties going forward, whereas litigation doesn't do that at all. It really just looks at what happened and finds solutions based on the past, and then, as I've said, applying them. So in the case of mediation, the outcome, we deal with a specific kind of mediation, which is called facilitative mediation, where the parties themselves work together with the assistance of the mediator to couch their own solution. It's in their hands. It's their solution at the end of the day. We don't tell people what to do. We don't decide who's right and who's wrong. In fact, we may not do that. We leave it up to the parties themselves, and we've just got wonderful ways of encouraging and helping parties to overcome the trauma of conflict, to deal with their emotional state, and then to work together to find solutions. And the solution is theirs. And so we find in a mediated situation, there's never an appeal, there's never an unhappy party, because the parties themselves have come to the solution. Whereas in litigation, the party that loses is always unhappy. I can guarantee you that. And wherever possible, that party will take the matter on appeal and stretch it out for that much time. So in the case of mediation, we really focus on the importance of dignity and restoring the relationship between parties. That's what facilitative mediation is really all about. It's about identifying dignity violations on both the party, on the part of both of the parties, taking care of those, and then couching these amazing solutions that are beneficial to everybody. In a hospital doctor dispute, you uncover problems with the system. The system problem is solved. It doesn't just resolve the conflict between the immediate parties. It resolves the conflict for everybody else that follows in their shoes and is faced with a similar situation. So a conflict is quite common. It's normal. It's natural. But it creates these opportunities for transformation. And that is what we really want to emphasize here. Not just for the parties, the immediate parties, for everybody else. So just a quick summary of the adversarial versus consensual mechanisms of dealing with conflict. In the adversarial stage, a fight is an adversarial way. What's happening in Israel and Palestine at the moment, that's adversarial, that's a fight. Litigation is also a form of fighting. Just have somebody to assist you, some clever advocates and attorneys to fight for you. And they fight your case, that's what they do. Arbitration, there's very little difference between arbitration and litigation. The only thing is arbitration is not out in the open, but it's as much a fight as litigation. It takes longer, it's more expensive, there are a lot of disadvantages. And then we look at the consensual ways. Of course, negotiation is the prime consensual way of dealing with conflict. Mediation, facilitative mediation that we advocate is nothing other than assisted negotiations. So as I'll show you in a moment, we work very hard to create an environment in which the parties can find themselves. So our job as mediators in consensual conflict resolution is to create an enabling environment. We do that very well. So here are some of the important features of mediation that enable us to do that. It's all of these essential features are to create this magic environment so that people can find one another. Firstly, in normal negotiations, there's never an agreement as to how you're going to negotiate. In the case of mediation, we always have a written agreement to mediate. What does that mean? It means that the parties bind themselves in advance to certain rules as to how they're going to engage with one another. When, where, how, according to what principles, and I'm going to deal with some of those principles in a moment. That's the first important difference between ordinary negotiations and mediation. Okay, you've got an agreement that tells everybody how this thing is going to take place. The next important thing about mediation is we always have, in advance, authority to settle. So unlike many of the negotiations I was involved in as an advocate, where the advocate on the other side says, look, I don't have authority, even the people often don't have authority to settle. In the case of mediation, we don't go into the process without somebody on the other side, either personally having authority to settle, which is our priority. We always try to achieve that, or having somebody with the necessary authority at the other end of a telephone so that the person can, in fact, arrive at a solution, not faced with this difficulty that you often have in normal negotiations where the person can't enter into an agreement because they simply don't have authority. The next important feature of mediation, certainly the mediation that we practice, is it's a voluntary process. And that means we really try and ensure that the people come to the negotiating table because they want to. They want to give it a try. And then we also say to them right at the beginning, that also means you can leave whenever you like. Now, that sounds to all of you, I'm sure, that are not familiar with this process, so, well, that means people can walk out. Not that easy, because we make it a term of the agreement to mediate that you can only walk out. You can walk out whenever you want to. That's how mediation works. But you must talk to the mediator first. You must explain to the mediator why you want to leave the negotiating table. And you must then give the mediator an opportunity to address that if he can. And in my experience as the mediator, because of the manner in which the process takes place, you can always keep people at the negotiating table. So we can keep, as mediators, negotiations going as long as is necessary to get the parties to reach consensus in a collaborative manner by just having this thing that you can't walk out unless you talk to me first. And so that's a very powerful tool in our hands. The next essential feature of mediation is confidentiality. You know, the main function of a mediator is to create trust. And creating that trust requires a very high level of confidentiality. There are two levels. One is everything is confidential. Nothing can be repeated outside of the mediation. But there's another level of confidentiality that is so important. And that is that in the mediation, we don't all meet together all of the time. There are times when the mediator will take each of the parties separately and talk to them alone. And everything that the mediator is told in those private sessions is confidential unless the party says it's okay, you can share that. So you have the second level of confidentiality, creating the safe space where somebody speaks to you openly and honestly and shares with you stuff that they wouldn't want the other party to hear. Now, the trick is this. I can't tell you in how many cases that I've mediated. People say to me, listen, this is the situation, but I don't want the other party to know that. And then I leave them and we carry on and we earn trust and we show them that we really can, we really want to help them. And then at the end of the day, we say, look, you said this to me, but you didn't want me to reveal it to the other side. I actually think it would be helpful if you give me a mandate, if I think it'll be useful, only if I think it will be useful to say the following that you told me earlier. And then normally you get a mandate to do that, and it's very powerful. So this issue of earning trust and gaining the second level of confidentiality in communication doesn't exist in ordinary negotiation, but it exists in mediation, and it's massively powerful as a tool to create this enabling environment. Next thing also about mediation is it's without prejudice. What does that mean? It means essentially that nothing that is said or happens at a mediation can serve to prejudice any of the parties if the mediation is not successful and the matter has to go to court or to an arbitration. So one of the rules, and it's a signed rule, part of the agreement, is it's without prejudice. You cannot repeat any offer, any proposal, any concession. For example, a doctor might have it on its heart to apologize. A patient might want to apologize. The hospital superintendent might want to apologize. If they do that and the matter is not resolved in the mediation, they can't use it later. And the penalty for trying to use it later is massive. You can have a retrial, you can be liable for all the costs. So this is not something to be taken lightly. It's a powerful tool to create the safe space and safe environment. The next essential feature of mediation is it's not binding until a written agreement is concluded. Now, why do we say that? Why? And people often say mediation is non-binding. That's not correct. It's only non-binding up to the stage where the agreement between the parties is documented in writing and signed by the parties. So why do we have this rule of non-binding until a written agreement is signed? Simply because, unlike negotiation, we want in mediation to encourage parties to try all the possible ideas, put them on the table, put them out there, see how they receive, and know when you put the proposal on the table, you can withdraw it later. So you can actually withdraw an apology. You can withdraw an offer to allow somebody to use your seaside home. You can withdraw an offer to do this or do that or do the next thing. Nothing binds you until it's written down and it's signed. And that's also hugely powerful in getting people to be inventive in and around possible solutions. Massively powerful feature of mediation. The other thing, of course, it's a controlled process. So unlike negotiations where advocates walk into rooms and they walk out and they storm and they get angry with one another, this doesn't happen in mediation. We as the mediators control the process. So we make sure that every party gets an absolutely controlled opportunity to explain to the other party why they are there, to share, to vent, to say angry, to say they're angry without interruption. Super, super, super important. And everybody gets the same opportunity. So that's one thing that we control. The whole issue of interruptions, the issue of respecting the process, the issue of who says what when, in what order, that's all in the mediator's hands. He controls the mechanism. He doesn't control the outcome. But controlling the mechanism is a super powerful tool to create the safe space within which parties can collaborate in order to find a solution. So the other thing that I've mentioned already is the parties retain autonomy over the outcome. We control the process. They control the outcome. And for that reason, people are happy with the outcome. It's very, very rare in a mediation environment. You'll find somebody turning around later and saying, no, look, I'm not happy with it. I haven't had it. In 10 years of mediating, I haven't had it yet. I'm still waiting for the time for somebody to turn around later and say, well, I didn't want to agree to what I agreed to. I mean, obviously, it's your solution. You You spoke to the other side. You guys collaborated. You decided. I didn't tell you what. And we very much advocate a situation where we don't tell people, because the truth of the matter is you can't imagine yourself in somebody else's shoes. And it's presumptuous to do that. You don't know what's really important to somebody else. You might think you know, but you might be unbelievably surprised that there's something else that is far more important to that person than what you think. So we have to give parties an opportunity to find what is actually in their best interest. And so they have this fantastic autonomy over the outcome. Thank you for changing the slide. So this slide speaks to something that you understand very well as medical practitioners. Why do we have this preemptive consent form, this clause that we suggest you all have in your contracts and that should be put into hospital admission forms? It's really so that when people decide they want to go the consensual route or they want to go the adversarial route, that they take an informed decision. You as medical practitioners have a responsibility, an inherent responsibility, to describe to patients what the risks are of particular options in their treatment. There's nothing like that in the law. So we have tried as mediation in motion mediators to create this space for the same thing to happen to people that are on the point of deciding consensual or adversarial, because it's the same thing. You know, consensual is like taking a tablet. Adversarial is like undergoing a massive operation that's going to have a huge impact on your life and on the lives of everybody else, directly or indirectly involved, family members, etc., etc. So with this clause, mediation in motion mediators, and as far as I know, we are the only entity that suggests this. If you put this clause into your contract, it enables you to ensure that nobody is going to take a decision to go the adversarial route without knowing that there is an alternative, without knowing about the tablet, because all of the members of our organization, and we are over 650 strong at this point in time, we're the biggest mediation organization in Africa, probably one of the biggest in the world. Every single mediator that has qualified through our academy has undertaken to do these pre-mediation meetings free of charge. There's no obligation for people to use your service. There's no obligation for them to pay you anything. So what we do during these pre-mediation meetings is we ensure that both the patient and the doctor, or the two doctors, or the doctor in the hospital, or whoever the conflict involves, that those people know about mediation, that they know how it works, that they essentially realize that by participating in this process, I've got absolutely nothing to lose. I've got nothing to lose. It's without prejudice. It's confidential. It's off the record. I can withdraw anything I've done until something is signed. What have I got to lose? It costs very, very, very little, relatively speaking. Let me go and try it and see what it gives me. And if we can get parties that far, that they are addressed by a qualified mediator, and he shares with them how mediation works, we find I have not had one single pre-mediation meeting where the parties have not agreed to go the mediation. And so this is the tool, this is the magic wand, that if you put this in your agreement, it's binding, contractually binding on everybody, including yourself, that if there's a dispute, if there's a problem, whatever kind of problem it may be, party cannot go and litigate against you until, or vice versa for that matter, until you've gone to a pre-mediation meeting. It costs you nothing. You can't complain that it's cost you much and so on. It costs you nothing, and then everybody takes an informed decision. Should we mediate? Should we go the adversarial? So very, very good method of ensuring that people take informed decisions whether or not to go the consensual or the adversarial. So thank you. That's for me. I'm here ready to answer any questions that you may have. Thank you again for the opportunity. And Salma, congratulations on this project. I think it's a fantastic idea.
Thanks,
So,
Alan. Good evening, everyone. And yep, once again, thanks to Alan for that wonderful introduction to the mediation process. I myself am a trained mediator, and it never ceases to amaze me, how the process actually works and what it does for people who find themselves in conflict. So I'll just pick up from where Alan left off in terms of the actual nuts and bolts in terms of the process of mediation. And so, as Alan was mentioning, that we have specifically structured a clause that doesn't take away a person's right to litigate, but does in actual fact, force them, for the want of a better word, into a free pre-mediation meeting. So what happens at this meeting is very interesting, and really it's there to ensure that the parties take an informed decision as to whether they want to enter into the mediation process or not. So in terms of the process at MIMM, we normally get a request for mediation. And as Alan said, we have over 650 mediators who've been trained, and they normally conduct a free pre-mediation meeting. And during this pre-mediation meeting, they would go through all of those different features that Alan spoke about in terms of it being, voluntary and without prejudice, non-binding, and so on and so on, and really sets the scene for what to expect on the day of the mediation itself. The other opportunity that we take during the pre-mediation meeting, of course, is to decide the mechanism by which the mediation will be done. Now, in recent times, I think brought on by the COVID pandemic, we started to find a huge uptake in or towards the online or virtual style of mediation. And basically, that is where the mediation is done completely via a platform such as Zoom or Microsoft Teams, even Skype for that matter. And we found it to be hugely successful. But of course, the traditional mediation in itself can happen in a face-to-face setting. And that's where now you would normally have to decide on a venue and ensure that the venue is comfortable for the people and so on. Obviously, we decided the date, the time, and most importantly, we select a mediator that is highly specialized for that matter. And this is really done with both parties in combination. So we have a mechanism, that's our website, where we have all of our mediators who specialize in different categories, for example, medical, legal, or commercial matters, family. The mediators then the parties would then look at narrowing it down to the mediator that they want. And then they send a request to that mediator, to be involved in their matter. The most important thing, of course, as Alan said, is that we use this opportunity to get a signed agreement to mediate. And really, the signed agreement to mediate is the rules of engagement. It is contractually binding both parties to abide by all of these different features and characteristics that allow us as mediators to control the process and to create that safe space for the parties to now start talking to one another and really explore, out-of-the-box ideas in terms of solutions and so on. And as Alan said, you'll be absolutely amazed as to what comes out in these sessions, with regards to solutions. So once we've completed the pre-mediation meeting, and like I said, we've set a date and a time and a venue, we proudly say that we offer facilitative mediation. It's a very unique form of mediation as compared to the other types, which are adjudicative and so on. And the reason is, during facilitative mediation, we create a platform for the parties to come up with their solution. And in this way, we find that there are no comebacks, there are no negative connotations towards the outcomes, purely because it's the parties that have decided how to resolve this conflict. What we would do on a typical mediation, of course, is we call it setting the table, where we address everyone and we once again just quickly take them through the rules of engagement for the day. Then we very uniquely, and we are the only body that does what we call a coaching session. And during the coaching session, we pull parties independently, so one at a time, and we kind of figure out, is there any expectation from us in the day? Are there any limitations? I mean, especially in this day and age with load shedding, for example, if we are doing virtual mediation, are there certain times that they cannot be involved? If it's a medical matter, if the patient requires any reliefs during the day and so on. Then, of course, we prepare them and really encourage them to speak, what's on their hearts and their minds during the session. But most importantly, to also listen to the other party what they are saying during their opening remarks. Of course, then we bring the parties together and allow them to have this exchange. You know, from experience, it's normally very emotional, it's very heated, but you control the process as the mediator. And once you've allowed these parties to have that exchange, we then start the most important part of the mediation, which is the exploration. And here's where we now break out into what we call private sessions. And we can have as many of these as we feel necessary, so that we can gather enough information in terms of exploring the conflict, exploring the person, exploring the relationships, and so on and so on. And during this exploration, we train our mediators to really look for pieces of gold, as we call it, so that we can use these nuggets in terms of putting out the fires in the other party's mind, trying to address their dignity violations. And once we feel that we successfully do this, it's almost like a light bulb goes off, and the mediation almost flips, where the parties now start to talk to each other rather than at each other, and really start working together now to form what we call a settlement. Usually at this point, we negotiate, and we also do train our members on negotiations. But then, of course, once all of it has been agreed upon by both parties, we reduce it into writing, and that becomes a signed agreement, which can be made an order of the court as well. So that's our process. I want to quickly use the next couple of minutes, if you don't mind, and if my screen changes, to basically tell you a little bit about this pilot project that we're doing. So, as you would have heard right at the beginning, we want to make sure that all the members, whether it's SAMA and all of the different stakeholders, see the value that mediation brings when it comes to conflict resolution in the medical space. And so here we've consulted a statistician who told us that for a project like this here, we need a very small sample size. And so we've decided on a sample size of 9 matters, but we split these 9 matters into 3 categories that we find most often in the medical negligence space or medical legal space. So category 1 is the classic category, and that is a matter between a patient and a doctor. And we are hoping to find 3 cases like that there. Category number 2 is what we're starting to see also now crop up quite a bit. This is a classic dispute between 2 practitioners. So whether it's an anesthetist and a surgeon, or anesthetist of the same practice, or so on and so on. And we try to, or we would try then to use mediation to help bring resolve. Category 3, of course, is a dispute between a practitioner and a hospital. We're starting to find this also increasing now in this day and age, where we're starting to see the medical legal space being a easy target for advocates and the like, or attorneys and the like, to try and convince parties to sue hospitals as a favor, or as a means, I should say, of getting some monetary compensation. So what we're going to do with these 3 categories, of course, is once we mediate the matter, we would compare the time that it's taken to resolve the matter versus litigation. How we would do this is look for matters on similar merits that have been resolved, for the want of a better word, through litigation. We will determine how long it took, and of course, how much it cost. And then we will do that comparison. I think more importantly, is we will get the informed consent of the parties during this project to participate in a post-mediation survey. The survey would be a combination or mixed method a survey, where we would look at both quantitative and qualitative aspects. I don't want to spend too much time there, but this is the proposal that we have submitted. The quantitative pieces will be on a Likert scale. Qualitative pieces will be, via an interview, and we want to really find out, how did the parties experience mediation as a process? How did they feel about the mediator? How satisfied they were? Did they feel safe during the process in terms of, confidentiality breaches, and so on and so on. And really, this information we would use now to critically write a report in terms of whether the members and the patients who were involved in the mediation itself had a better experience. Once we do that, we aim to publish the results, so that we have now a non-disputed document or a mechanism to show the benefits of mediation over litigation. In the interest of time, colleagues, I want to stop there. I now want to hand over back to Trevor, who would quickly take us through the recent advances that SAMA has made with regards to the indemnity insurers. So Trevor, I'll hand it over to you.
Thanks very much, Jamal. So just quickly want to touch base on or mention about the different kind of consents. You will have gathered, I'm sure, through the speakers that much of the outcome rests in the hands of the parties themselves. So first of all, we do need an agreement to mediate, which is signed by all the parties, the mediators, and the legal professionals involved. And that is affects both the choice of mediator and also the commitment to confidentiality, so that anybody who is involved in the mediation process must bind themselves to the confidential nature of mediation. The other important part of the process where the consent of the parties is needed, as already described, is where one is sharing information from the private side sessions. Information shared in those sessions with the mediator may only be conveyed to the other party with the consent of the party who gave that information. And then, as it was mentioned, the mediator will look for pieces of gold, and when it is useful, the mediator will suggest or check if they can use that information. And then finally, the settlement agreements are the result of the consensus between the consent between the two parties as to what it is. So if you can move on, please, Jamal. Okay, so the question is often asked, can my lawyer attend my mediation? And the answer is absolutely yes. And what's the role of indemnity insurers? So first of all, it's really important that the interests of all parties are protected. So let's again take a situation where you have a patient and a doctor who are in a dispute. And again, you might have that imbalance of power and knowledge between the two parties. And that is important that a patient or a family who have suffered harm, that their interests are protected. So they are entirely entitled to have some legal assistance. It is very important that the focus is on the parties themselves. It's not where the lawyers speak for the parties. The parties will speak for themselves. The patient, the doctor, the family, anyone else who has been harmed or has been involved. So certainly MIMM and I think most of the mediation organizations welcome the presence of attorneys to assist the parties. Not in all cases, but in some cases, legal principles become relevant. Is there wrongfulness? Is there negligence? Is there a causal link between what happened and the harm that was suffered? And then what are in terms of quantums, what are the legal precedents? And it's important to remember that litigation is always an option. However, so when the attorneys may be representing a party, they may not use anything that occurs in the mediation in a formal litigation process. So as mentioned, mediation is without prejudice. It can't impact on any formal litigation process. Then the other thing is that the attorneys can very often assist with a reality check for the parties who are involved. You know, a patient who might feel that she can justify a 40 million rand payment for her baby who has some birth injury. Well, an attorney should advise her that's highly unlikely and you need to moderate your expectations. And I think we welcome the engagement with our indemnity insurers. SAMA has had 2 meetings recently with indemnity insurers to understand their view of mediation. They have expressed keenness to be involved early when they know that there's a case, and then they would also like to see how this pilot project unfolds. So I think that's all on that side. So, Shema, okay. I think that's from us. Thanks.
Thanks, Trevor. I think, next on the agenda was the next steps, but perhaps, Dr. Human, in the interest of time, we could hand over to Dr. Oosthuizen, who could maybe open up the floor for any questions or comments. I think that would be more valuable to our members, and we can always kind of summarize the next steps. So with your permission, Dr. Human, if that's okay.
Absolutely, thank you.
Look, perfect. No, thanks so much, everyone. Good evening. And thanks so much to the speakers for highlighting this very exciting project that we're launching. I hope that many of you aren't locked in disputes, but those of you that are locked in disputes, please consider bringing that dispute to the SAMA mediation unit. There are a couple of interesting questions on the chat. Let me start with this one from Dr. Strauss. In order for a medical practitioner to have settlement authority during a mediation with a patient, there must be buy-in from the practitioner's medical malpractice insurer. How will that be addressed? I think, Trevor, you touched on it. Do you perhaps want to go into more detail? And Alan, you're welcome to also chime in.
So in terms of, thanks very much, William. In terms of our engagement with the indemnity insurers, they do want to be involved. They do represent the interests of the practitioner. They also represent their own interest, clearly as a business, and in terms of managing the resources they have to deal with conflict situations and particularly claims that have to be paid out. So our current situation, or SAMA's situation, is that the professional indemnity insurers will be involved from the beginning. Clearly, they have a say in the end if they have to pay out an amount. However, I think it's important to recognize that there are many other ways in which mediation resolves conflict. So money is always helpful. I think it's a useful phrase, but it is not the only solution to conflict. I'm not sure if Alan wants to add anything.
Yeah, so we encourage parties to address conflict as soon as possible. And I want you to see in context what Trevor has said about all the legal principles. We really try and encourage parties to say, look, those can be dealt with if necessary. But let's make sure that it's absolutely essential that you want to go that way. Because mediation is not designed to deal with legal issues. The process itself doesn't include all the witnesses, doesn't include the experts, doesn't include the discovery of documents, doesn't include cross-examination, doesn't include legal argument. It's not a court. And so we encourage parties to say, look, if you want to go that route, you can. But bear in mind the following consequences. One, even if you win, you're not going to recover all of your costs. Somebody told us the other day that in the Transvaal currently, parties are recovering where they win cases 20% of their costs from the other side. They have to pay 80% of their costs even if they win. Those are the kind of reality checks that we would like to do also on the insurer. And what I have found in the past is once you do that, insurers are often willing to come to the table to make some kind of contribution. And sometimes the doctors do in different ways. I'll redo the operation. I'll get the best guy in the country who's my mate to do the operation, to remedy the situation within the next month. I'll talk to the hospital. I can do this. I can do that. So we really encourage parties to say, look, okay, all of those things could be relevant. If you want to be sure on those things, then go to court. And by the way, you're never even going to be sure if you go there. Rather, let's look at what's really important. Let's look at the future. Let's look at taking care of this thing in a manner right now that everybody's going to be happy with. I am really excited about the fact that SAMA have managed to get the insurers on board, because until recently, the attitude of the insurers, I know, was that they did not support mediation at an early stage. They said, well, let's get the discovery, let's get the expert summaries, let's find out whether we're liable or not. And one can understand why they take up that attitude, but that's not in the interest of the patient or the practitioner. So if those issues do remain, there are ways that the parties can take care of them without necessarily having to go to court. You can engage an outside expert that everybody agrees is the top man in the business to look at the facts, look at the file, to then help parties to understand whether they're liable or not. And that can be part of the mediation process. It doesn't have to be over in a day. It can take as long as it's necessary. You can have a few mediation sessions spread over time. But in my experience, once parties start to look at what's really important to them, once they focus on the future and not on whether a mistake was or wasn't made or whether somebody's liable or not liable, we find these amazing solutions coming forward and everybody being happy with the outcome. So it's kind of a very rare thing for parties to dig their heels in around legal liability. And we manage that as mediators, if necessary. But we say, okay, hang on, let's see whether you can't find an outcome that you'll be happy with. If it's essential that we go the legal route and we decide these legal issues, then yeah, we can take care of that. But let's first explore other alternatives. Let's see if there's another way out of this. So, and yeah, it's fantastic that the insurers are on board as far as that is concerned. And I really want to congratulate you, Sama, because I think for the first time you stood together as a body and you've said it's in our members' interest, as it's in the patient's interest too, to deal with these things as soon as possible. And we want you there from the beginning. And you must also take informed decisions as to how the matter is dealt with. And I've had matters where there's been no liability in terms of expert opinion. But the insurers have said, look, if this matter goes to court, we'll be in for so much money. We won't be able to recover all of it, even if we win. So yeah, we'll put that money on the table as part of an incentive to the other party to reach an agreement. And that's the beauty of mediation. You can put all these things, all these possibilities.
Oh, thanks so much for that. It certainly is a very positive development. They were very receptive and supported of this project and had wanted to become involved at some later stage. So we're very, very happy with where things currently stand. There are a couple of other questions in the chat. Here's a very positive one for the group. It's a comment from Dr. Kutsia indicating that she had completed a mediation course, perhaps through one of the competitors, we won't say. But she wants to know if perhaps in future there would be an opportunity for her to actually form part of this mediation group and this project. And I certainly hope so. That was one of the hopes in launching this initiative, seeing after the pilot whether perhaps there would be an opportunity to perhaps upskill SAMA doctors to play a role, to perhaps be observers in some of these pilot mediations. So I would certainly be very happy if it ends up going that way. But let me bring in Trevor to perhaps also speak to the question.
Thanks very much. So we are conscious, I think, from MIM, side, that there are people who have been trained through other organizations. Not sure that we call them competitors, but other organizations. And I think we are looking for the same outcome. We're looking for better ways to resolve conflict. And right now, the proposal is for MIM to provide the mediators for SAMA members or patients, for example, who might raise an issue through SAMA. But I think what is important is to recognize is, immediately with the SAMA project becoming quite real, Advocate Nelson offered an upskilling course immediately to people who've done the medical negligence mediation course. So they've done this over the last couple of years, but most of them have not had experience. And we're developing a protocol that could stand up to scrutiny, because we are following, it's not a textbook or recipe, but at least there are important principles that must be included in the mediation under the MIMM project. That does not exclude, so first of all, I think, and we'd have to check with MIMM Exco, if other people wish to attend the refresher mediation course, a medical mediation course, would MIMM be open to that? I don't think there's any objection to that. We do want skilled mediators, and I think that as doctors and as mediators to do the mediations. So I think it is a case of other people, people who have been trained in other organizations could well be part of the team, but we need to make sure that they're following what we've agreed with SAMA to introduce. Yeah.
Perfect. Thanks so much for that clarity, Trevor. I see we're almost out of time. Any of the other questions that the attendees might have, feel free to put those in the chat or to send an email, and we'll get back to you with comments from the panelists. Let me throw it over to Dr. Mark Human, or the chairperson of SAMA, to close this meeting. And just once again, thanks so much to the speakers. This really is an exciting initiative, and we hope it makes a difference in the health landscape. Thanks so much.
Thank you very much, William. For me, it's really just to say thank you very much to my colleagues at SAMA and the team at Mediation in Motion Mediators. In particular, I need to mention Dr. Trevor Frankish, who really has been at the heart of driving this whole process. Initially, when we started from the Gauteng branch of SAMA, and then with our interactions through the Department of Health, through AIMS-DI and the Bioethics Center, and the Human Rights Law and Ethics Committee has had this on our dashboard literally consistently for 5.5 years. The decision to partner with Mediation in Motion Mediators, once it came up, became really obvious and necessary. And I have to really commend Advocate Alan Nelson and Dr. Shamal Ramesar for their contribution, for engaging with us, and really just for helping us take this forward. They have the experience. We have the will to get it up and running, and the need is absolutely of paramount importance. The last figure that I heard mentioned South African figure for contingent liability. I don't know how many of you are familiar with that concept. It's obviously not normally a number that is ever realized. This is the claims against the state for litigation of one or other medico-legal misadventure, was well over 130 billion rand. That's literally 50% of our government's annual healthcare spend. And clearly we need to find much more constructive ways to deal with this. The Law Reform Commission has been working on this for about 5 years now, and the Medico-Legal Association has made big inroads into this. We've recently had some further comment from the Law Reform Commission that they've added criminal liability. That's obviously quite important in many people's minds, following the criminal charges laid against some of our colleagues recently. So thank you very, very much for everyone that has been involved. This is obviously the exciting start of a process. We have a lot more to work on, and we really ask for all of you to contribute where possible. You expect to see things like this. I'm about to share a screen coming out. Expect to share things like this coming through on media platforms. Please engage with us. It's going to be a learning process for all of us, for Mediation in Motion Mediators, and especially for SAMA, quite a steep learning process. And we look forward to engaging with all of you. I think that brings us to an end for our session tonight. Thank you very, very much, everyone who's been involved. Trevor, I don't know if you have any parting words.
Yeah,
or Alan,
sorry, I just see the questions about what happens next. And I think if we can say that the next step is to get mediations, run the pilot project, and then that will guide us on how we actually implement this. Thanks.
Thank you, Trevor. Alan, I'm not sure if you have any closing comments.
Mark, just to say this, that we say as mediators that what is the best time to mediate? Some of you may be involved in disputes at the moment. and very concerned about that. And I'm sure it's in your life. We say mediate as soon as possible, but it's also never too late. It's never too late to do it. You might be involved in a case. It might already have gone to a lower court. You might be on appeal. I've had matters referred to me by the Supreme Court of Appeal to mediate. So it's never too late. Take your dispute to mediation as soon as you possibly can. Don't wait. Don't have another day's trauma hanging over your head. Just get it out there, contact SAMA, and they and Trevor will take care of it. Ensure that you find it suitable. So yeah, I bless you all and hope that this project really comes off the ground. I'm married to a medical doctor. I have brothers in the industry. So yeah. I wish you well, and thank you very much for the opportunity to speak.
Thank you very much, Alan. Thank you, everyone. Good evening.
Good night, everyone. Bye-bye.